Good morning, good afternoon, or good evening, wherever you may be in the world. My name is David Horrigan. I'm Discovery Counsel and Legal Education Director at Relativity, and welcome to the inaugural episode of the I-Team. I have three of my good friends and colleagues here, and the four of us thought we would get together and put together a program where you can learn about the international aspects of data law. I work in the United States, have the United States perspective. We're going to talk about a few things that are in the news these days as far as data law goes. We have Fiona Campbell with Field Fisher here in the United Kingdom. We also have Jonathan Armstrong with Punter Southall Law, and of course Linda Sheehan, who visits us from South Africa from ENS. So before we kick things off, like I said, I've got the American perspective. We're going to try to keep things peaceful here, and we will go to the first of all, English perspective, but you're going to find that some people here on this program are in multiple jurisdictions, so they can tell you about multiple perspectives. How about our friend Fiona Campbell?
Hello, everyone. Thank you for having me here today. Thanks for having me for the first podcast. So I am going to speak from the UK perspective, mainly from the legal perspective in terms of the courts, regulatory matters, and how AI law is being shaped in that degree. So I'm happy to speak about it now, just to give a general overview. Within the confines of the courts, it still is undefined in that AI law hasn't been specifically endorsed for usage, as in AI itself in litigation hasn't been endorsed. What we have is a legislative setup where the use of technology-assisted review and other technology is allowed. So what's been happening is that practitioners have been leading the way and agreeing amongst themselves to use GenAI within procedural workflows, be that for litigation, arbitration, regulatory matters, or internal investigation. And there really is a new shape forming, and the judges seem to be receptive of that. So I'm happy to speak a lot more about that in time, but I will pass over to Jonathan for now to give his tuppence worth.
I suppose my hobby horse at the moment is around hallucination. So those of you physically in the room in the UK and those online from the UK will know that the last couple of days have been fairly significant from a hallucination point of view. So we had the judgment handed down in two cases on Friday, and then a statement from about a working group on the Civil Justice Council this morning. And if it's okay with you, I might just outline a little bit about the two hallucination cases, because I think they're really interesting. So as at the 27th of May, databases had tracked more than 120 cases of hallucination. So for those of you not familiar with hallucination, this is people using ChatGPT and other GenAI to draft court pleadings for them. And in some cases, those court pleadings have included cases that didn't exist because ChatGPT or some other GenAI made those cases up. And those cases haven't just been in the UK and the US. I'm on the New York State Bar AI task force, which was formed to look at Avianca, the famous US case. But there have been cases as well as the UK and the US in Canada, Australia, New Zealand, and I now hear South Africa. But where I think this is relevant is I think it's gone from, I wouldn't say merriment, but it's gone from being slightly inconsequential, so sparring in court between advocates of you've made that up, to sanctions. And I think we're seeing that courts are really losing patience with hallucination, and probably the two cases where we had judgment on Friday probably show that. So the first is a case called Ayinde, London Borough of Hackney. The second is called Hamad Al Haroun against Qatar National Bank. And in both cases, it seems that a substantial volume of hallucinated cases were put before the court. And they may lead to disbarment for the solicitors and barristers involved. The hearings on Friday were about contempt of court, So whether jail sentences potentially were going to be handed down. They weren't handed down, but the court did remind lawyers that potentially contempt of court proceedings could be brought, and potentially the police may be involved in future cases, which could include perverting the course of justice. And the president of the King's Bench Division said that could include life imprisonment, obviously in very extreme cases. So I think judges have gone from sort of rapping people over the knuckles and telling them to do better to giving concrete guidance.
Life is tough.
Life is tough, I think, particularly for use of ChatGPT, right. although it could be an appropriate penalty. And I think one of the other aspects of the case is that the president of the KBD says that the onus is on heads of chambers for barristers and senior partners for solicitors' firms to educate the lawyers in their businesses about hallucination, and said that that there would be hearings, contempt hearings, where it was likely that the firm or barristers' chambers involved would be asked questions about their training. And in some respect, this fits in with the EU AI Act as well. So law firms, barristers' chambers, etc., are all under a duty to make sure that people using AI are AI literate. That's defined by Article 4 of the EU AI Act. And those provisions are in now. So they've been in since February. And a lot of people talk about the EU AI Act coming in a future date, but those provisions are already in. And so that whole literacy obligation, I think, is going to be interesting, as well as the issues around hallucination. I don't know if you want me to say more about Ayinde. I think it's a really interesting case. I mean, the other...
I think it'd be great if you did, but why don't we take a visit to South Africa with Linda, and then we'll go around the horn. Linda, what is going down in South Africa these days?
Well, thank you. Jonathan stole my fire a little bit because I wrote down 120 cases on a database. But if it's the same database I've looked at, the South African case law is not on there.
Wow.
I can't get South African cases in the US.
Well, there aren't that many. We don't have as many reported, but we did have one that was reported at the beginning of the year. And it's a very interesting read. I think the judge is very well-spoken in the way he explains it, but it very much mirrors what Jonathan's talking about. So it is a case between Mavundla and a number of respondents from the municipalities, but it follows a similar pattern to the UK case from last week. It really, for me, shows how you've got more junior people who are doing the legal research, and they are using these tools such as ChatGPT, and it's really about supervision that didn't happen by the looks of it from the more senior person and also counsel. It was actually the judge who picked up that they were the fake citations. There was quite a lot of time spent by court clerks in the libraries looking to try to find these cases. So I think just to kind of take it a little bit further from what Jonathan's saying, it's not just about, the contempt of court. It's not just about the unethical practice of not verifying, but it's also the time that's spent by other parties, which again brings in new sanctions. So there was the discussion on this one about wasted costs, which they were, and it was quite substantial. There were specific hearings to discuss whether these judgments actually existed. And then also the solicitors have been reported to our law commission for potential disciplinary actions. So, it's actually a very serious matter. And it is being taken very seriously by the UK courts, but also the South African courts, and you can see across the world. So not to be down about it, but I think it really raises quite a big issue around supervision of our more junior people. It's not necessarily about the technology they're using in the background, but it's also just making sure that there's verification of anything that's going into, court papers being filed or arguments being used in a hearing or a mediation. I think AI is raising an already human issue that's in play.
Thanks, Linda. Jonathan mentioned the Avianca case, and we are fortunate to have a live studio audience with us here today from the International Legal Technology Association. And let's ask them, this Avianca case is Mata v. Avianca, Inc. How many of you in our studio audience have heard of that case, if you raise your hands? We'll give you a brief bit of background because it's an interesting story. And for those of you who are not legal professionals who want to find out about this, it began when Roberto Mata was on an Avianca Airlines flight. He is coming into New York's JFK Airport. And of those of you who have any height whatsoever, you have probably had this happen. I know I have. The infamous drink cart coming down the aisle. The drink cart hits Mr. Mata in the knee. Mr. Mata sues for damages. Then you get to the stage of litigating the case, and the lawyers are doing their legal research. The issue is, not to get too into the weeds, but did they wait too long to file their case? And it is the Montreal Convention that governs this because it's an international plane flight coming into the US. And so the lawyer filed these cases, and somehow the court's looking at them and like, gee, these don't, something, they can't find the cases. And the cases are good. Even if you're a lawyer, you wouldn't necessarily know that these are not cases. So they went back and they found that there is a problem, Houston. We don't have cases here. Turns out he had used ChatGPT. And the court asked him this, and I'm simplifying the fact pattern because we want to get on with the other topics we've got today. So the court asked him about it, and so what does the lawyer do? Goes back to ChatGPT and say, hey, are these correct cases? Well, yes, of course they are. Goes back to the court, didn't double check it. Now, we are not sending people to the gallows, Jonathan. The lawyer involved got only a $5,000 fine.
Yeah.
But what was worse for him, and at least in my mind, is that he had to send a copy of the court's judgment of the $5,000 not death fine and send it to each of the courts where the fake cases were coming from. And so this was a real problem for any lawyer who has a professional reputation to uphold. But as we talk more about these hallucinations, I'll get Jonathan to give a deep dive, if he's up for it, on some of his cases. But before we end our show today, we're going to talk about some good news potentially in some GenAI cases and how GenAI in the law is really possibly having a good effect. And then we're going to get into American Bar Association Formal Rule 512. And if you're about to fall asleep and your eyes are about to glaze over, we'll bring that one to life too. Jonathan, why don't you get into those? And Fiona, then we'll get back to you on what you want to contribute on GenAI.
Yeah, I think of the two cases that we've just had, that Al Haroun is the easiest in some respects. This is a solicitor who allowed his client to draft documents for the court case. And the client included citations to 45 cases that didn't exist. And the solicitor had not checked that they did exist. He'd not followed the citations through. And I think slightly amusingly, they were caught out because the citations included references to a case decided by the judge who was hearing that hearing. And she thought, I don't recall that one, and then looked more into the citations. And this one, the application was just struck out, and there's an SRA investigation is following into the solicitor. As I said, there was a contempt hearing, but the solicitor, the contempt hearing decided that effectively the SRA would be better placed to investigate. And that's sort of the same result in INDI for different reasons. I think there's all sorts of object lessons in INDI, one of which is if you've made a mistake, make a full and frank confession and apologize to the court. A great idea is not to deceive the judge and to try and lie again, which I think is probably the failing of the barrister in this case. So in INDI, it's a case about housing, and the barrister seemed to be somebody with experience of housing cases, although she was junior in her bar career. And again, she had citations of cases that didn't exist. And she seemed to try and double down with the judge by a somewhat complicated explanation of saying that it was the fault of a filing system that she used, where it seemed that she was saying that sometimes she printed the cases and put them in a special folder, and sometimes she had a special electronic folder, and it was somehow the fault when she retrieved them from the folder. Obviously, the judge said, well, if the cases didn't exist, how could you have printed them out and put them in that box? And it seems that the barrister really, I think, didn't know when she could turn a loss into a disaster in some respects. This was raised initially by the solicitors on the other side in correspondence. And we now know that she drafted a letter for Haringey Law Centre, her instructing solicitors, which effectively told the other side not to be picky. And it said, I'll just, if I can, I'll read
please.
it because I think it's an object lesson. So the letter included the words, "We regret to say that we still do not see the point you are making by correlating any errors in citations to the issues addressed in the request for judicial review in this matter. Admittedly, there could be some concessions from our side in relation to any erroneous citation in the grounds, which are easily explained and can be corrected on the record if it were immediately necessary to do so. We do not think that our duty of care should go as far as to provide legal interpretation of the laws for your benefit. We hope that you are not raising these errors as technicalities to avoid undertaking really serious legal research." So effectively, when the hallucinations are raised, she sort of backs it back through her instructing solicitors and tells them to find the cases and do their own homework. The judge who first heard the case called it, quote, "a remarkable letter." And I think it probably, there's all sorts of lessons there about, you know, everybody makes mistakes, but sometimes you have to fess up and apologize rather than go on the aggressive route of telling people, you know, I believe you youth call it gaslighting, don't you, these days?
That's the modern term, Jonathan.
And thanks for
I'll
thinking
get
I'm
with
a
the
youth.
And I was interested in this particular barrister, and it's probably wrong to single her out because I suspect others are doing this as well. But it seems, using the tool I did, more than 30% of her professional resume is also written by AI. And I just think that maybe is a generational thing, but maybe, as we've already said, one of the object lessons, I think, is supervision. You know, I don't wholly blame the barrister concerned. She's relatively junior. She says there was little or no supervision by her chambers, and I think that's one of the reasons she's avoided a contempt finding, because I think the judge is thinking that maybe the fault is partly with her chambers and not just with her. But it's not going to end well, I don't think. There's a costs order against the law centre and against the barrister involved. There's an SRA investigation, a BSB, a Bar Standards Board investigation. And I don't see it's going to end super well, not only for the hallucination, but also, maybe I'm old-fashioned, but I never thought it was a good idea to mislead a judge.
That seems brilliant to me. Fiona Campbell, your take on it?
So we're all aware of the perils of AI misuse. However, AI is a tool. It is not a decision maker. And with any AI use, including the judicial guidance from 2023, 18th of December, AI must be used and verified if used. So courts do recommend, or they would in some way suggest, that AI can be used for case summaries, for drafting pleadings if it is admitted to, and only for assistance, never to actually draft the whole thing. But like anything, it is there for lawyers to use like any of the tools we use, and to ensure that we independently go back over and ensure that whatever output we are providing, it is independently looked at before it is provided to the court. There were another few points I wanted to make. So we have two other individuals in the room, and we all worked on an ILTA, GenAI best practice guidance. And that guidance is for practitioners using AI. For now, we have suggested that it is used in tandem with active learning, simply because that shows verification and it shows that the science behind it, which is already accepted since 2016 in the Pirro case in the UK by the bench, can be there to prove how anything was arrived at. And what we've done is we've designed a guide that gives information on designing prompts, on controlling risks, on having effective audit trails. It's designed with flexibility and adaptability in mind. However, it's not anything like a binding protocol or prescriptive or technical document. But for practitioners who do wish to use it, it is something that should be considered.
You know, here's the thing. You bring up Pirro, which of course was the seminal case in TAR law, we call it. That's technology-assisted review for people outside of our bubble. We had De Silva Moore in the United States, Quinn in Ireland. Of course, Fiona mentioned Pirro. Is there any case law in South Africa on TAR, Linda?
So there's not. We very much, like any case law that you ask about, we don't really have existing legislation that is as mature as AI at
But
this
you're at
level.
a very sophisticated law firm. I mean, it's not just the Wild Wild West out there. What do you do?
No, so I always use this example. So our disclosure rules or discovery rules in South Africa, they still expect us to go to, the written law expects us to go to the opposing parties' office with our hard copy documents for inspection, and we'd have our photocopier 50 cents. That's what our rules say. So we don't do that, just to set the perception. We very much use the maturity of the technology between the two opposing parties, and we agree on a case by case basis. There is obviously a divide in South Africa, as there is with any jurisdiction, but I think we do have a bigger divide, just the way that the law firms are set up in South Africa. You've got, big law firms, and then the majority of law firms are sole practitioners and, regional. So they don't have access to the same type of technology. But I mean, in terms of TAR, we do use it, but it's not used in the same way as the UK. We use it in the background to be more efficient, but it's not the same, if I can say, agreement with the parties or the court that's required. There's no guidelines in place, so we have to step up as practitioners and make sure that we're doing it to the same level that would be expected in the UK.
Gotcha. I told our audience that I was going to make your eyes glaze over with a bunch of rules, but there's one that the American Bar Association put out last summer that's Formal Opinion 512. And it is a great roadmap. What it really does is it takes the existing laws, I shouldn't say laws, it takes the existing rules from the Model Rules of Professional Conduct. In the United States, that is what governs lawyers, and not just lawyers, it's the entire legal team, because the lawyers are responsible for reporting to the clients, but everyone involved, there are rules that say, the lawyer's responsible, everyone, it's a team here. But as far as GenAI, there's some interesting ones. And one thing that's come up is, do you have an obligation to tell your client that you're using GenAI? Now, in Mata via Avianca, I'll bet Mr. Mata might have liked to have known that he was going to ChatGPT. And there's a big difference. We obviously are here with a software company, and we don't want to be biased here, but the tools matter. There's an old expression, it's kind of trite now. If you get an app or software for free, you are the product. And so if you're getting it for free, or even if you're just paying $20 a month, it's probably not something you're going to want to put client data in. But Jonathan, what about the rule in the United Kingdom? Do you need to disclose to your client that you're using ChatGPT or any other generative AI?
I mean, our rules tend to be sort of principles-based rather than black letter. My suspicion is you probably ought to. I think we're encouraged in engagement letters to be open and honest with clients about the technology that we're using. and you probably have transparency obligations potentially to other people as well. And those transparency obligations will come in when that bit of the EU AI Act comes in, and already exist in GDPR. So in GDPR, we have 6 general principles, and one of them is about honesty and fairness and transparency. So there are probably already obligations that you have to use AI. And I think you're definitely right. I can probably say it, I don't have to be as delicate as you do, that AI solution providers weren't born equal. Yet these cases are about free-to-air applications. In some cases, it might be that the barrister involved didn't even know that they were GenAI because she was just using Dr. Google to do her legal research. And there's definitely a marked difference between I don't know, I like to say a not cheap solution, where you know that somebody's looking after the data, where you know it's secure, you know that you're feeding intelligence from data that you've harvested, versus GenAI products. And I think when we did the work on New York State Bar Association Task Force, the reason for that is clearly because if you're doing research on legal problems, there are only so many people who own that pot of data. The obvious people being Thomson Reuters and LexisNexis. And if they're not prepared to give their data away for free, then why should they? Then what is GenAI, when answering legal questions, being trained on? Well, the answer, it seems, is things like Reddit posts, because they're using an intermediary called Common Crawl to crawl the internet for content. And the easiest content to get on legal views is Reddit posts, often from non-lawyers, saying, do you know what, mate? You don't need to pay the parking ticket because you can use the Magna Carta. And that type of nonsense then extrapolates into GenAI and self-confirms. So that's why we get people appearing, my wife's a magistrate, we get people appearing in court citing Magna Carta as a defense to their parking fines, because this nonsense proliferates in chat rooms and Facebook, and then is given the imprimer of reality by GenAI. So I think it's very different to use what I'd call proper AI in a solution like Relativity than common free-to-air GenAI. And the reason for that is often the data that it's trained on. And like you say, if the product is free, then it's going to be free information that's being used to train, partly because some of you will have read the court cases. Thomson Reuters have refused to provide their information to market entrants.
May I make a couple of ancillary points on that, Jonathan? There is a difference between using OpenAI to create things like pleadings or any of the submissions that the horror stories are based on. So when you're using it to create, it's very different than taking your own data set in the likes of Relativity and doing things like summarizing, creating dramatis personae, creating timelines or any kind of chronologies. So the very successful AI use cases we have been using Relativity over our own data. As lawyers, we would not use AI to draft anything because, again, our job as lawyers is to know the law and effectively use it. And if we do use AI, we verify it. So often the horror stories come from either lay litigants or individuals who don't really know how to research and verify the tools once the work is done. So I might say, although we have heard some, shall we say, slightly scary stories about AI today, I've had nothing but a good experience because we've used it within frameworks and guardrails and for the uses for which the courts expect us to use it. And again, we sign off as lawyers and we ensure that everything done has been spot checked, quality controlled and verified before it is submitted.
Brilliant segue, but first, Linda Sheehan.
Sorry, just to add to that is also, I completely agree with everything that's said. We use a couple of different tools, and there's two key things: verbatim and citations. That's one of the biggest differences between using a ChatGPT, where it gives you what we call a free response. So it will try to answer. If you ask it a question, it wants to answer you. Whereas if you take a tool like Relativity or other generative AI that we have, you can specifically say verbatim, or Relativity is designed only to provide you with responses where it can pull a citation, which is effectively pulling out a smoking gun paragraph in an email that it's found. And that's why it's saying that this document is relevant or hot, or, speaks to one of the issues in your case.
Right, and for the lawyers out there and the paralegals and the people in the legal field, this is not a legal citation. This is a generative AI citation.
So it is a direct quote pulled from the document. And the GenAI in Relativity will it'll pull out one or up to 5, I think, citations from a document. That's its proof, that's its evidence. That's why it made its determination. It will also explain to you why it thinks a document is relevant or not relevant. But if it cannot pull a citation to match its rationale, its reasoning for that document being relevant, it says, sorry, couldn't analyze. And ChatGPT will never come back to you and say, sorry, I don't know.
Good point. And, I too told you I was going to tell you some good news about the use of generative AI in the courts. And there are a couple of cases. One of them we discussed when we were here last year, and that is the Snell matter. This one is sort of an entertaining fact pattern, except that someone got hurt. The Snell family decides they want to build a trampoline in their backyard, but not just any trampoline. They're going to put the trampoline in the ground, so it is a ground level trampoline, so no one falls off. And you're looking at this and saying, well, wait a minute, they're close to the ground. It seems very predictable that someone will bounce and bam, hit their head on the side. And of course, that is exactly what happened. But there's no hallucinations here. This is a federal judge from the 11th Circuit Court of Appeals, which is one of the important federal courts in the United States. And it was not the court's opinion, it was just a concurring opinion. But the judge said, what about using ChatGPT to write opinions? And this was an insurance case. This issue didn't decide the case, but it comes down to whether the insurance company was going to cover the loss. The insurance company said no, because the policy covers you for landscaping. Now, the landscaper here put in nice shrubs, did in many other things, did the whole backyard, including the in-ground trampoline. So what the judge did in this case was use generative AI to make the definition of what is landscaping and defining terms. And that is something at which it can be brilliant. And this brings it back to what we talked about at the top of the hour about it's a tool, not something that is going to be a panacea. And I think in a lot of these cases where people have been sanctioned, it's because they want ChatGPT to do their jobs for them. You're not going to take a chainsaw and have the chainsaw go down and prune the forest. You're going to need a human operator. And the courts have told us this. One of those quick things, get back on communications. Do you need to tell your client? The United States rule is the typical legal thing. It depends. In Formal Opinion 512, they went back to ABA Model Rule of Professional Conduct 1.4 in communication. And the really bottom line is it depends, but also if your client asks you, then you've got to disclose. That seems like a real low, no-brainer and a pretty low standard. And is Mr. Mata going to think of that? Especially, you got to look when this case was. It was right after ChatGPT first came out. Mr. Mata is nursing the wounds he's claiming, not thinking about the tools that the lawyer is going to use. Any ideas on what we can do to make sure that clients are aware, or, that we don't tell them what legal research tool we're using usually?
I think now there is an expectation that firms are using GenAI, and most firms have introduced their own GenAI task forces and have adopted software across the board. Many firms have pilots, so there's almost an expectation there. In terms of what Jonathan was saying earlier about the UK principles. There are 5 principles, one of which is transparency. So in line with that transparency principle, there is, I would say, a requirement to let clients, other side, and court know that GenAI may have been used for some aspect, but not necessarily to do the job. Now, in terms of the actual court work, there is a disclosure review document for disclosure, whereby you set out what tools you're using, particularly if you are using TAR. Again, the task force has updated that to consider GenAI use. So there is now a new portion within it where we would ideally set out what GenAI is used, and the other side is then invited to come back and ask questions. But ultimately, the desire is to use it and to keep the momentum of using GenAI continuing.
I wonder if one of the issues that in some of these cases, and a lot of the US cases that I've seen tend to be people saying, oh, it was a Friday night, I had stuff to get to, therefore, as a shortcut, I used these systems. I think a lot of it is that lack of understanding. So, you know, the requirement under the EU AI Act, for example, says that you have to give your employees, consultants, service providers, people working on your behalf, the, quote, skills, knowledge, and understanding. And I think a lot of people are using things even like, I don't know whether any of you do, even if you use a common browser and you say things like, I don't know, how quick is it to get from King's Cross to Waterloo Station? That answer is being AI generated as well now. And I think that's a change even in the last 3 or 4 months, that AI is becoming much more prevalent. And I think a lot of our lawyers, particularly senior lawyers, don't actually get the fact that that is an AI-generated result and could therefore be unreliable. I know there's a little bit at the bottom, but speaking now for lawyers of a certain age, some of us can't read little print like that across the bottom, and you've got the answer you wanted. You're probably not going to read this minute bit in 4-point type above the bit in 14-point type. So I sort of agree with the judgments in these 2 cases, that I think there is a role for firms to educate people across the board, not just those who are obviously using AI, but those who are doing stuff like putting things into search engines, which I think all of us are.
Yeah. Fiona?
I was going to say there's a certain degree of elasticity to it, and what I like to compare it to is things like autopilot or cruise control. You still have the lawyer doing the job, but AI is assisting on the journey. So if you're using it solely to produce what you mentioned earlier, Jonathan, with some of those submissions, then yes, that is not how you should use it. It all goes back to effective and responsible use. And this is like anything. And also, you know, there's an Alan Turing type idea behind it. There is always a man or woman behind the machine. And that is where we come in as practitioners. It is there as a very helpful tool, but to be used properly.
Good point. Linda, what you got?
Sorry, I'm just looking for the exact wording, so I might have to come back to it.
Keep looking, because we've got some other way that generative AI is being used, and this was in an appellate court in New York just recently. Gentleman is litigating. He's a 74-year-old litigant, and Mr. DeWald is making his appellant oral argument. He was pro se, meaning he was representing himself in this case. And he's at the appellate court, and you know, even for a lawyer or a legal professional, that's some pretty weighty stuff. You might get nervous. And so he was making his presentation to the court, and it's a video presentation, so he doesn't stumble over his words. And the court's reviewing the record, and I'm like, wait a minute, Mr. DeWald is 74 years old. This guy looks, he's like about maybe 30 sitting there. And so the chief judge of the First Appellate Division asks, is that your lawyer? I'm like, no, I created him. And he explains to the court, and the court snapped back at him, the judge, like, well, it would have been nice to know that beforehand. Lack of candor to the tribunal, as they call it. Anything else popping up around the world that you've seen where people are going in? You know, in the United States, we also had the I am not a cat.
I was about to say.
Yeah, everyone knows I am not a cat. For those of you who don't, it was in the middle of the pandemic when court hearings were on Zoom, and someone's kid, I think it was a kid, decided to put a filter on. And so you have a judge, a couple of lawyers, and a cat. And the cat's mouth is moving just like the lawyer's mouth is moving. And he's like, Judge, sorry, I am not a cat. The judge was later interviewed saying he almost couldn't help himself from cracking up. But it's the way people are using technology. They're going to be mission failures every once in a while.
I think you're seeing it. I've had a subject access request case where I'm almost sure the answers to our letters were in part generated by GenAI. And it's a litigant in person, and you can obviously ask the question, are you using GenAI? And in this case, she got really offended and didn't answer the question. But I think there's this whole myth that AI will streamline the courts, and giving litigants in person, AI will streamline the courts. And I think it's a nonsense. I think if you look at a lot of the cases that we see, they take up far more court time, far more court resources, unpicking. You know, if you file 200 citations and 45 are incorrect, some humans got to do the work to unpick those from the court proceedings and the court file ahead of the hearing. And so things like the avatar is amusing, and I definitely recommend everybody go and look at it. But I think it is almost a portent of doom, really, because if we're going to have litigants in person appoint virtual attorneys and they're not subject to the professional rules, which are meant to be the brakes on this sort of stuff, then we're in difficulty, aren't we?
It would seem that way, Linda.
Just to kind of go, I agree with you. But I mean, there are people who are introverted or, have throat cancer or a disability where an avatar would help. I disagree with the 20 years younger avatar in that case. I would also go for something that looked a bit better. But I actually quite like the idea of it to just make, court hearings a bit more accessible. But there's a lot of issues there. And I was just checking I hadn't hallucinated. That's why I was taking a minute. No, just to go back to the point around subscription paid versus your public ChatGPT. It's actually in our the recently released guidelines for the use of AI, so particularly around generative AI in arbitration in South Africa. I wanted to check because I couldn't see it immediately, but they just say prefer subscription services with robust confidentiality protections. Refrain from public AI tools. Don't put in your confidential data. And I think, the AI policy that the arbitrators have brought out really, talk to everything that's been said here, but you can see there's a very strong wording for guidelines saying don't use the free stuff. Just use your subscriptions, Thomson Reuters, Relativity, others. So that's the point I wanted to get to, but I was worried I hallucinated, so I wanted to verify and
May
fact
I
check.
just add to that point? I'm not sure if this is an urban legend or true, but at RelFest a couple of years ago, the London one, in one of the talks, someone mentioned that using open source AI, one expert put in his expert report and said in his prompt, what would you say, or what would the other side be expected to say to the content of this report, to which he received, before filing, the other side's full report. So again, this was a warning about the perils of using anything on OpenAI or putting client data or confidential data in, because it is then used to train the model and retained. And even when you draft a prompt without actually sending it, all of that information is still kept.
I think it's very important. And the other part is, as lawyers, hopefully we're not doing it, we're well trained, but our clients also may not be so trained, and they might be asking to summarize your very lengthy explanations. So there's education to many people when you're dealing with legal and confidential information.
Sadly, it looks like our time today for the episode is coming to a close, but why don't we go around the horn with our closing thoughts, and what the biggest takeaway for today is on generative AI, and why don't we start with Fiona Campbell?
Thank you, David. I think my thoughts on GenAI is to use it, but use it with guardrails, use it effectively. Don't shy away from it. The horror stories are few and far between. The goodness and the good stories far outweigh though.
And Jonathan?
I actually agree with you. I think I agree with everything you said. Having looked at some of the horror stories, I think it is inevitable that we will use AI. We just need to be careful about it. And we need to resist the thoughts from some in government that we can reduce court resources because AI is the answer. I think at least in the short and medium term, we'll need more court resources, not less.
Yeah.
And Linda Sheehan?
I also agree.
Kumbaya, we're all in agreement.
I'll keep it short. We're using it as much as possible. It's very much an encouraged tool to use at our firm, but we have very strong guardrails in place. We have very specific steps that need to be taken. So if you're using a subscription-based type of ChatGPT for summarizing, as we do, our juniors must take the response from the GenAI, their changes, and both go to the partner. So there does need to be and I think just from the UK cases from last week, top down is absolutely imperative that everyone is understanding where the risks are and putting those mitigations in place. But it's amazing, it's fun.
Thanks, Linda. And I'll close it out by saying we've seen perspectives from different parts of the world. And the interesting thing is how similar they all tend to be. Use common sense. And it's tough because it's a new technology. You're not going to take a fast motor car and go speeding around the cliff, even if it might be fun, even if it might get you there faster. Sort of like just going to ChatGPT and turning in some cases. So we're all for going to keep our eye on the law, the rules, how they're changing. And we'll try to throw some interesting cases in there as well. Would be they cats, airplanes, in-ground trampolines, or in some cases, someone who looks much younger before an appellate court. For Linda Sheehan, Jonathan Armstrong, Fiona Campbell, my name is David Horrigan. Thanks for being here for the I-Team. Have a great day.